Constitution, and cases quite often do come from the state Supreme Courts to the U.S. Supreme Court. But what I really think perhaps is interesting, both from a historical point of view as well as contemporary struggles in the political system here in the United States, is to look at the issue of philosophy or ideology and how much that plays a role in the Supreme Court, both in terms of the president who appoints the justices, in terms of the senators who pass or approve or disapprove in some cases the nomination, and then the justices themselves, once they get on the court, how much of their own personal philosophy or what we call ideology plays a role in their decision. And this, of course, it gets into a lot of the recent controversies of confirmation. In Sotomayor's case, she was, by implication, heavily criticized and cross-examined before the Senate Committee, Judiciary Committee, as to whether or not she was too liberal. And when Alito and Roberts appeared a few years ago for their confirmations, the same, questions were asked from more liberal senators, mostly Democrats, were they too conservative? And then this cross-examination based on philosophy or ideology leads to the justices or the nominees themselves being very careful about what they have to say when they go before the confirmation process. This goes back to the 1980s when President Reagan nominated a guy named Robert Bork to the Supreme Court. Robert Bork had been a very outspoken conservative judicial scholar. He had taught at Yale Law School. Among his students were a lady named Hillary Rodham and a guy named William Jefferson Clinton, who both, I understand, got A's in his law school classes. He later said he wished he had failed them both. Because when Bork was before the Supreme Court, he was grilled on his support for a whole series of what we might call judicial review cases of the modern era that altered traditional patterns of Supreme Court precedent from the past. You recall Professor Frederick mentioned that the Supreme Court in law in general has a principle called stare decisis, which Dr. Barchay also mentioned, a Latin phrase which means stand on the decided cases. So the cases of the past have some bearing on the present, and that goes all the way back to the first one I'm going to talk about in a minute, Marbury versus Madison. So how often should and can these justices depart from precedent and go in a new direction, or perhaps overturn precedents that were established in an earlier time? The classic example, of course, is the case the Supreme Court decided in the 1890s that legalized Jim Crow segregation in all kinds of ways of life in this country. That case was Plessy versus Ferguson. It was the reigning precedent from the 1890s right up into the 1950s, and then it led to things like segregated schools, segregated military, segregated everything in much of the United States. Supreme Court, as many of you know, overturned that decision in the early 1950s in the Brown versus Board of Education case, a unanimous 9-0 vote. But it was a major, watershed era decision in American history. And that was obviously done because the justices did not stand on the precedent, but they rather decided that the old precedent was decided wrongly. Supreme Court can do that, and that, of course, gives them an opportunity to inject their own, you can call it philosophy, ethical standards, ideology, or even a bias if they individually or collectively decide to do so. My view of the judicial review is that it's very difficult to separate politics and law, or our decisions based on constitutional principles versus political philosophy or ideology to some degree. Let's take the first case in American history that is the starting point of judicial review, and that was John Marshall, who wrote the unanimous decision in 1803 in Marbury versus Madison. This started out as a political dispute, a philosophical dispute between the Federalist Party, headed by, at that time, John Adams, who was the second president, and his opponent, his good friend and opponent, Thomas Jefferson, who defeated him in the election of 1800 as the head of the new party called the Democratic Republicans. And their philosophy or view of government, the role of government, particularly the national government, was quite different. The Federalists were for a strong national government, strengthening the president, the Congress, and the judiciary, as we'll see. And the Jefferson's Republicans were, they call themselves advocates of states' rights, and they wanted just a very minimal role for the national government and as much autonomy for the states as possible. Anyway, the case got started because some of Adams's nominees, sometimes called the midnight judges, were appointed, and their documents were signed by Adams, and he left office at midnight. Jefferson was sworn in the next day, and the commissions for those judges had not been delivered. One of them, a guy named Marbury, who I think was perhaps had property land and lived in just general area of PG County, filed a lawsuit against Jefferson's Secretary of State, Mr. Madison, who was taking care of his official business. So the case came to be called Marbury versus Madison. And it came down to whether or not this, the law that Adams appointed Marbury to the position under, whether that law was really valid. It was called the Judiciary Act of 1789. In a very complex legal argument, I'm not going to try to summarize it, but to cut to the chase, the Chief Justice, John Marshall, and the unanimous decision of the court was that the Judiciary Act of 1789 was unconstitutional, and Marbury didn't get his commission. Now, this case was the beginning point of judicial review, and I have been to the Supreme Court a few times, and there is a famous quotation on the wall of the Supreme Court, a quotation from John Marshall from this case, Marbury versus Madison, and it sets the standard for the court even now. Marshall said, "It is emphatically the province and duty of the judicial department to say what the law is." That means that unless the Constitution is amended, or unless Congress can get around a decision by artful rewriting of the law, that the Supreme Court has the final say on the meaning of the law and the meaning of the interpretation of the law, and that includes very ambiguous phrases in the Constitution. What does due process mean? What does equal protection mean? What is an unreasonable search and seizure, particularly in a time of high technology like we have today, when your conversations can be heard at great distances, and your electronic communications that you walk around with are not by any means secure from, let's say, law enforcement. So, but anyway, this has been the claim of the Supreme Court for over 200 years, that they have the final say on deciding what the law is and whether the law conforms to the Constitution. In other words, that puts the Supreme Court kind of like a referee or an umpire, in one sense of the word, vis-a-vis the other two branches of government in the states, having to say as to whether those laws and the actions of the president, too, whether they are in conformity with the Constitution. Yes, presidents can and do violate the Constitution. And the Supreme Court occasionally, much more rare than in cases of Congress or the states, but it's declared acts of presidents unconstitutional. So anyway, getting back to the issue of philosophy, the main differences between the conservative and liberal interpretations today are on this issue of how aggressive or how active they should be in exercising judicial review. And at times, conservatives have been activists as well. As a matter of fact, I think we've got an activist majority on the Supreme Court right now. They're getting ready to probably strike down the McCain-Feingold bill, which limits spending for for corporations and labor unions in elections, in a case called Hillary the Movie. But be that as it may, in general, in the 20th century, it has been the more liberal justices that have wanted to expand the scope of the First Amendment on liberty or the 14th Amendment on equal protection that have been likely the most activist. The conservative justices like Justice Scalia and Justice Roberts, who, by the way, I think Justice Roberts is certainly following in this tradition of activism laid down by appointees since Reagan to carry the court in a conservative direction. And their major ally, Justice Thomas, by the way, is from Georgia, so he is a Southerner, isn't he?